USCIS Background Check 2026 one mistake that can destroy your case. The interview was going well. Every question answered clearly. Every document organized in the right order. Every response calm, composed, and consistent with what had been filed months earlier. Then the officer leaned forward. She asked one question that wasn't on any checklist, wasn't in any preparation guide, wasn't in any forum thread the applicant had read in 3 years of research. And in the silence that followed, that 3-second pause before the answer came, everything changed. Not because the answer was wrong, because the pause itself had already been noted. A background check flag that had been sitting quietly in a federal database for 11 years, something the applicant didn't know existed, didn't know could be accessed, and didn't know could be used exactly this way, had just surfaced at the worst possible moment. This moment didn't unfold over months of legal proceedings. It unfolded in 45 minutes. 45 minutes that could end a green card case. 45 minutes that could trigger a notice to appear before an immigration judge. 45 minutes that could separate a family that had been building a life here for over a decade. One piece of undisclosed information, not a crime, not a conviction, just a record, became the entire case. What the applicant didn't know had crossed a line that USCIS had been quietly tightening for the last 2 years. And when that line was crossed, the officer did not hesitate. She responded with documentation, referral, and a case hold that stopped everything cold. Most people in this situation panic. They try to explain in the room. They say things they shouldn't say without an attorney present. They fall straight into the trap. But today, you're going to do something different. For years now, there had been signals, not from official USCIS press releases, not from formal Federal Register announcements, just signals that the agency was quietly expanding the depth, scope, and integration of its background check infrastructure in ways that most applicants and even some attorneys had not fully absorbed. USCIS had been methodical in this process, yes, but also aggressive in how it connected the dots between databases that were previously siloed. Their actions followed a pattern, a sequence, almost a deliberate convergence, one that was designed to close the gaps that had allowed incomplete disclosures to pass through adjudication without consequence. But what triggered real alarm among immigration attorneys and advocates in 2025 and into 2026 was that the agency's enforcement posture on background check issues went from reactive to proactive without a public announcement. Officers who handle applications, not just naturalization cases, not just green card renewals, but initial adjustment of status filings, and even some non-immigrant extensions, began asking questions and requesting documentation that pointed clearly to a background check system with far more reach than most people assumed. Immigration law professionals who monitor USCIS adjudication trends recognize the indicators. The sudden increase in requests for certified court records from applicants who had disclosed minor incidents years ago. The growing number of case holds tied to pending FBI name check results. The expanding use of Interpol and foreign law enforcement database queries for applicants from specific countries. The sudden appearance of questions during interviews that referenced arrest records, civil immigration violations, and administrative proceedings that applicants had been told were no longer relevant. And when USCIS quietly expands its reach into areas that applicants assumed were resolved or irrelevant, something significant is about to be enforced at scale. Earlier this year, immigration attorneys across multiple major cities began reporting what they described as a marked increase in case holds and requests for evidence tied specifically to background check discrepancies, including a pattern of agency inquiries into records not seen with this frequency in over a decade of adjudication. These are conditions USCIS only creates when it is signaling something deliberate. A coordinated sweep of pending cases where background check elements were treated as resolved but weren't. A new cross-agency data sharing protocol that gives USCIS faster access to records held by other federal departments. Or a policy recalibration at the adjudicator level, one that instructs officers to treat any discrepancy between what was disclosed and what the background check reveals as a potential misrepresentation rather than a simple omission. Observers and practitioners weren't certain which of these was driving the change, or whether all three were being implemented simultaneously. But one thing was unmistakable. USCIS was changing its posture on how background check results are used in the adjudication process. And when an agency changes how it uses information it has always collected without telling applicants, the consequences arrive without warning. The updated enforcement framework being applied to USCIS background checks in 2026 is not routine. It is not symbolic. It is structural, and it reaches further back into an applicant's history than the questions on the forms suggest. Attorney after attorney reviewing denied or held cases this year has described the agency's approach as thorough, aggressive, and most importantly, willing to treat old records as current liabilities, meaning that something which happened 10 or 15 years ago, was never prosecuted, or resulted only in a civil fine can now be the basis for a finding of willful misrepresentation if it was not disclosed at the time of the application. But enforcement only works when applicants don't understand what's happening until it's too late. The attorneys who have been paying attention did not wait. They went back through their clients' files. They audited prior disclosures. They filed proactive supplemental statements before USCIS raised any flag. Their response was among the most decisive moves seen in immigration legal practice in years, because they understood that the window for voluntary correction is brief, and once USCIS finds something you didn't disclose, the story changes completely. This year, multiple immigration law organizations confirmed that USCIS has deployed an expanded background check processing system targeting pending adjustment of status cases, naturalization filings, and certain non-immigrant benefit applications, including a new interagency data pipeline that had recently been activated for what analysts believe was designed to create a unified federal identity and history record accessible to adjudicators in real time during interviews. They acted before applicants could prepare responses. They targeted long-pending cases where background check results had been marked as cleared under older, less thorough protocols. They targeted cases involving applicants who had any prior contact with law enforcement, even contact that never resulted in charges. They targeted applications connected to petitioners or sponsors who themselves had records that created credibility questions about the entire filing. This wasn't a policy announcement. It was a quiet operational shift. And that is exactly what makes it so dangerous for the tens of thousands of applicants currently in the USCIS pipeline who have no idea this is happening. Here is what you need to understand about how USCIS background checks actually work in 2026 and why the mistake that destroys cases is almost never the actual record itself. USCIS conducts multiple overlapping background check processes for most immigration benefits. The FBI name check, the FBI fingerprint check, and the interagency check through DHS systems are the three most widely known. But the system also includes checks through the State Department's visa database, the DOJ's immigration court records, the Social Security Administration, and increasingly, law enforcement databases from applicants' countries of origin. The critical thing to understand is that none of these systems check only for convictions. They check for encounters, arrests, civil infractions, administrative actions, deportation orders, including ones that were vacated or expired, visa overstays, prior applications under different names, border crossing records. Everything that has ever touched the federal system under your name, your fingerprints, or your identifying documents is potentially accessible to a USCIS adjudicator reviewing your case. The mistake that destroys cases is not having a record. The mistake that destroys cases is failing to disclose a record that USCIS can find, and then being in a position where the agency's finding and your application are in direct contradiction. That contradiction has a name in immigration law. It is called willful misrepresentation. And willful misrepresentation is one of the most serious grounds of inadmissibility in the entire immigration code. A drug conviction from 20 years ago that was expunged, that is a challenge, but it is a manageable one with the right legal strategy. A drug conviction from 20 years ago that was expunged, that you did not disclose because you believed the expungement erased it, that USCIS now finds in its background check records, that is a potential permanent bar from immigration benefits. Not because of the original offense, because of the non-disclosure. That is the trap. That is the one mistake. Let me be specific about the categories of records that are triggering holds and denials in 2026 that applicants are consistently not disclosing, often because they genuinely did not believe they needed to. Arrests that did not lead to charges. Every immigration form that asks about your criminal history uses language that includes arrests. The question is not limited to convictions. If you were arrested, stopped, detained, or taken into custody by any law enforcement agency at any level, local, state, federal, or foreign, USCIS expects to know about it unless the form explicitly limits the question to convictions. Many applicants do not know this. Many were told by someone, a notario, a friend, a well-meaning family member, that if there was no conviction, there was nothing to disclose. That advice is wrong. It has always been wrong. And in 2026, the background check system is good enough to find the record even when the applicant is sure it no longer exists. Expunged records. Under most state laws, an expunged record is sealed from public view, and the individual can legally say the arrest or conviction did not occur in most civilian contexts. Immigration law is not a civilian context. For immigration purposes, an expunged record still exists. USCIS still expects disclosure. The FBI fingerprint database, the DOJ immigration records, and certain state-level systems that feed into federal immigration processing retain the underlying information even after a state court orders an expungement. This surprises people every single year. It is destroying cases in 2026 at a rate that immigration attorneys describe as one of the most consistent sources of avoidable case damage they are seeing. Foreign records. If you have ever had any contact with law enforcement in any country you have lived in or traveled through, not just your home country, that record may be accessible to USCIS. The United States has data sharing agreements with dozens of countries, and the scope of those agreements has expanded significantly under recent administrations. An arrest in Canada 20 years ago. A traffic stop that escalated in the United Kingdom. A civil fine that was processed through a court system in Mexico or India or the Philippines. These records are increasingly findable. And if they were findable and you did not disclose them, you are now in misrepresentation territory regardless of what the original incident was. Prior immigration violations. This category is the one that catches people who came to the United States years ago, built their lives, regularized their status, and believed that the earlier chapter was closed. A prior deportation order, even one that was never executed, even one that was entered in absentia because you didn't receive notice, even one that you didn't know existed, is a background check hit. A prior visa overstay that was never formally addressed. A prior application for asylum that was denied and then abandoned. A prior entry without inspection that has never been disclosed. These are not ancient history in the USCIS system. They're live records. They're being surfaced in 2026 in cases where they had never appeared before because the database integration is simply better than it used to be. Here is what you need to do right now if you have any case pending before USCIS or if you are preparing to file. You need to sit down, not with a friend, not with a family member, not with a community advisor, with a licensed immigration attorney who can ask you the full scope of questions that USCIS will ask. Review what the background check system is likely to find and determine whether your current disclosures are complete, accurate, and consistent with that record. This is not optional. This is not something to defer until after you receive an RFE. The window for voluntary disclosure, for proactively supplementing your application with information that creates a transparent, explained record rather than a discovered contradiction, is open right now. The moment USCIS finds something you didn't disclose, that window closes. And once it closes, the path forward is exponentially harder, exponentially more expensive, and exponentially more uncertain. If you are already in a case hold situation, if you have already received an RFE that references your background check, or if you have been scheduled for an interview and you know there are records in your history that may not have been fully disclosed, do not go into that interview without an attorney beside you. The right to have legal representation at a USCIS interview is one of the most underutilized protections in immigration law. Most applicants walk in alone because they believe their case is straightforward. Some of them walk out with a case that is no longer straightforward. An attorney present at that interview is not a signal of guilt. It is a signal that you understand what you are doing. It is protection. None of what is happening in 2026 is random. USCIS has been building toward a more integrated, more rigorous, more data-connected adjudication system for years. The technology is better. The interagency cooperation is deeper. The political will to apply it fully rather than selectively is stronger than it has been in at least a decade. The people who navigate this successfully will not be the ones with the cleanest records. They will be the ones who understood that the background check system finds what it finds and who built their case around complete transparency rather than hoping that certain parts of their history would stay invisible. Transparency, when managed correctly, is not a weakness. It is the strongest possible strategy in an environment where USCIS has more tools to find the truth than it ever has before. As this cycle continues, more applicants will discover background check flags they never knew existed. More cases will be held. More denials will cite misrepresentation. More families will be facing consequences for a single omission that felt harmless at the time it was made. But one thing is already clear. Knowing this right now does not make you a criminal. It makes you prepared. It means you have time to act before the agency acts first. It means you can protect your case, your status, and your family's future with the time you still have. Share this video with anyone you know who has a pending USCIS case or who is preparing to file. It might be the most important thing they see before their interview. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.